Good day, everybody. This is Michael Leveris from jurisq.com, where we bring you attorneys from different states, different practice areas to educate you on their field of law. And today we welcome back Kevin Attkisson, a personal injury attorney in Ohio. Kevin, welcome back.
Hi, Michael. Thank you.
Thank you. I want to discuss today a very common type of accident, a rear end collision. How do you determine liability? Is the driver who was hit ever at fault? What happens with the passengers? Whom can they sue besides the car that hit them? Can they also hit their own driver? Even though it sounds simple, I'm sure there are nuances to it. So let's get into it.
Absolutely. So we see probably more rear end motor vehicle collisions than any other type of collisions. They're very common, happen all the time. And technically, it's what we call a failure to maintain an assured clear distance. That means the driver behind, the at-fault driver, did not leave enough space between the front of his car and the back of the car in front of him to bring the car to a stop in time.
Okay.
And what we call within an assured clear distance. So we call it generically a rear end motor vehicle collision. So 99 times out of 100, the car to the rear is at fault. There are some circumstances where they can have a defense to that, but in general, they're going to be at fault. And usually we don't have any issue with liability. That is, who's at fault for the accident. And then the only challenge left is what is the person's damages, that is the injured victim's damages to their vehicle and to their body, assuming they suffered bodily injury as well.
Is there ever a time where a driver that was hit from behind could be at fault as well? And
Absolutely.
what if that's the case, what happens to the award now? Do they get a little less due to their negligence? How does that work?
Well, it's either going to be one driver's fault or the other for the most part. It would be kind of difficult to either one's at fault or the other. So what could happen is that the driver in front could cut off the person's assured clear distance. That is they're in the left lane, the other driver's in the right lane, and you get in front of them and then quickly stop and cut off their assured clear distance. You create what we call a sudden emergency, and that is a defense to an assured clear distance.
I see.
So the driver in front would be at fault at that point if they got into the lane and then suddenly stopped and cut off the assured clear distance. So that's a circumstance where the vehicle in front, the vehicle that is being struck, could actually be at fault for the accident. Another situation is, and we don't really see that often, is suppose you for some reason you're stopped at a light and you put your car in reverse.
I see.
You go backwards, and even if another car is coming up and you're going backwards for whatever, rolling backwards, or it was in reverse, then obviously the vehicle in front could be held at fault for that as well.
So Kevin, in that case, if you are a passenger in a vehicle where your driver was somewhat at fault and he was hit from the rear, does that mean you can now sue your driver as well as the car that hit you from behind?
Absolutely correct. Yes, and that's probably what I would recommend the passenger in the vehicle being struck to do. So if the person in the passenger vehicle and that vehicle cuts off the assured clear distance, that is, they come into the lane and then cut off the assured clear distance and suddenly come to a stop or slow down, they get rear-ended. Part of the fault could be on the vehicle from behind. Part of the fault could be on the vehicle in front. And so, yes, that the passenger obviously in the passenger seat would be an innocent passenger. They have no negligence whatsoever. They didn't do anything to cause the accident. So the responsibility for causing the collision could be a portion between the two drivers.
Ken, let me ask you then a practical question. Can one attorney represent both the passenger in that car as well as the driver, or they need their own separate attorneys?
There would be a conflict of interest if one person if the driver of the vehicle was partially at fault and the passenger was making an injury claim and they were both making injury claims. I would not recommend anybody to do that. You would want to get your own lawyer for each of those people. There would be a conflict of interest in that.
Makes sense. But if the driver is completely innocent of any negligence on his or her part, then can you then represent both the driver
Yes.
and the passengers.
Yes,
Okay,
absolutely.
perfect.
Because the driver's not at fault. The driver didn't do anything wrong. They're both
Mhm.
innocent victims at that point. They're both the victims of the negligence of the vehicle behind them, and they would both be entitled to damages. And I can't really conceive of any way that the passenger would have a claim against the driver because the driver didn't do anything wrong. Okay? So
Perfect.
the vehicle to the rear would be fully responsible for the damages for both the driver and the passenger.
Very good. Okay, thank you for clarification.